Hello and welcome to SpedFX. I am Dr. J, and my goal for this channel is to educate parents, students, administrators, and anyone else who might have an interest in learning about what federal law requires when providing services for students who are on an individualized education program. Additionally, I would like to help parents and schools work together more effectively for the educational benefit of their students. Private schools are not under the same obligation to provide services for students with disabilities under the Individuals with Disabilities Education Act because they do not receive federal funding. So if you are someone who works in that venue, these videos will not pertain to you. My doctoral degree is in instruction and curriculum leadership with an emphasis in special education, and I have taught and administered in public school settings for 25 plus years. I completed a paralegal certification program and worked briefly in the field. I also have an adult son with Down syndrome who was educated in the public school system for the totality of his educational experience. He has Down syndrome and 6 years ago started showing signs of dementia and schizophrenia. So I have had to quit my full-time job and in order to care for him. So I'm hoping that I can continue to help individuals with disabilities through this venue. So please take a minute to like and subscribe to my channel. It would really mean a lot. Today's episode is on the discipline of students who are on an individualized education program. And we're going to discuss what the law requires of schools for students who are being disciplined. First of all, each state has its own set of laws surrounding the provision of special education services. However, all states must abide by federal law as it pertains to the Individuals with Disabilities Education Act. So the things that I will be presenting are taken from federal law, more specifically 34 CFR section 300 et sec, for any of you who might be interested. When a student who is on an IEP, which is short for Individualized Education Program, when that student exhibits behaviors that may be suspension worthy, the school can do one of a couple of things. The school can either provide specific instruction to that student, make them participate in restorative practices and type things, or they can suspend the student. And most opt for option number 2, the suspension. The school may suspend a student who is on an IEP for up to 10 days in the school year. And those days can either be consecutive or they can be a series of removals that total 10 days. In-school suspensions count toward those 10 days unless the student is receiving specially designed instruction the same way they would be if they weren't suspended, and they have access to their same age peers. Many times schools will call parents if the child is having a bad day, a bad behavior day, and they'll ask the parents to come and pick their child up from school. If they do that, that must count as suspension time toward those 10 days. They can't just call the parent, keep calling parents and telling them to pick up their children. Each school should have a policy regarding suspensions and what constitutes a full day or a half day. So for example, if a student was suspended before 11:30 in the morning, they would have to count that as a full day. Or if it was after 11:30, it could be considered a half a day suspension. So you just want to find out what the policy is for your school. So what happens when the student has been suspended 10 times? Well, upon this 10th suspension, the school must hold what's called a manifestation determination review. And that is where the IEP team gets together and they discuss whether the behaviors that led to the suspension were a manifestation of that child's disability. Did the disability cause him or her to display the types of behaviors that they did that got them suspended? Or did the suspensions take place because of the school's failure to implement the IEP as it is written? Regardless, A functional behavior assessment must be done, and you'll hear that referred to as an FBA, and then a behavior intervention plan must be implemented. If a behavior intervention plan is already in place, then it must be revised. If in the manifestation determination meeting, the team determines that the behaviors are a manifestation of the student's disability and the suspensions constitute a pattern, like suspensions were for the same types of things, or suspensions always occurred right conveniently before field trips would happen, those kind of things would be a pattern. Or if the conduct in question was directly related to the school's failure to implement the IEP, then the student must be returned to the placement they were in prior to the suspensions taking place. Automatically, when a student has been suspended 10 times or more, it's determined to be a change of placement. So all it means is they need to put them back in the same classroom or set of classrooms that they were in prior to that 10th suspension. And that is unless the parent and the school agree to a change of placement. And then no further suspensions can happen in that school year for that student for those same behaviors that are deemed to be a manifestation of that child's disability, unless one or more of the following things occur. The first thing, unless that student brings a weapon to school. Or number two, that student brings drugs to school or is found in possession of drugs. And the third thing would be if they inflict serious bodily harm on another individual in the school. Now I'm going to just read to you what the definition of serious bodily injury is as it is defined in the United States Code. 18 U.S.C. section 1365 H3. Definition of serious bodily injury is bodily injury that involves 1, a substantial risk of death, 2, extreme physical pain, 3, protracted and obvious disfigurement, or 4, protracted loss or impairment of the function of a bodily member, organ, or mental faculty. So there's pretty steep definition there of what constitutes serious bodily injury. Schools cannot make up their own definition for what constitutes that. That is against the law. They must abide by the federal law as far as that definition goes. If the IEP team determines that the behavior was not a manifestation of the child's disability, then they may continue to suspend the student. However, parents must be given a copy of procedural safeguards, and the student must receive services on the days of suspension, unless the parents agree otherwise. Additionally, following each successive suspension, the following has to take place. First of all, they have to hold another manifestation determination review for every suspension following the 10. Second, the BIP has to be revised. And third, the IEP must be revised. This has to happen after every subsequent suspension again. And I know that sounds like a lot, but that is the law. What if the parent disagrees that the behavior and thinks that the behavior was not a manifestation of the student's disability, but the rest of the team does? Well, the parent does have rights to due process. They can file a due process complaint. They can file a state complaint. So you have options as parents if you disagree with what the rest of the team has to say regarding that. Okay, that concludes the information that I'm going to talk about today as far as discipline goes. There are many other topics that I'll cover in further episodes, but now I would like to move on to a section that I call Meet Me in the Middle. It has become a battle between parents and school districts in trying to provide services for students. Each school district and the parent both want to win with the things that they want or don't want to put in place. And it just feels like the one that is losing is the student in that type of situation. Additionally, legislators, both state and federal, continue to heap requirements on personnel who are serving these students with disabilities, and the requirements are untenable and impossible to implement without funding, and they are not provided any funding or very little funding from the federal government to implement the mandates of IDEA. We have to get together and do what's best for the student. If we do not, there will be no teachers left to teach. Depending on the source that you look at, special educators leave the field. There's an attrition rate of 50 to 60% within their first 5 years of teaching. Losing teachers directly hurts students. So please try to keep an open mind as I talk about these talking points, and know that the goal is to help you recognize things and see where we might be able to meet in the middle to make things better. For school personnel, continuing to call parents every day to come pick up their child for undesired behaviors is not going to work. It's not going to help the child progress. It's not going to help them change their behaviors. I know it feels like the right thing to do in the moment, but our goal is to help the child change their behavior. So we need to focus on the positive behavior interventions and supports, putting those antecedent interventions in place. The second thing we really need to focus on is training our educators better, helping them to have better classroom management, to respond to the needs of these students, make sure they're implementing the accommodations that they need to be implementing for that student. Time and time again, I have observed in classrooms where it's really pretty evident that the lack of classroom management is contributing to the undesirable behavior of these students. Make sure that all teachers and administrators understand what their duties are as far as administering special education, and that they are aware of those and that they are implementing. And trust, but verify. So those spot check-ins to make sure things are happening for our kiddos is really, really important. As parents, and I am one as well, we have to be involved in helping our children when they're displaying suspension-worthy behaviors. It's not enough, it's not desirable or helpful to say it's the school's problem. You have them during this time, it's your problem, figure it out. That's not going to help anybody. And saying they don't act like this at home, that's not going to help either. Of course, they're going to act differently at school. It's a whole different ballgame with lots of kids, lots of environmental issues, and demands that are placed on that child that they just don't have at home. Parenting is hard, and single parenting is hard times 1,000. However, we have to put our children first. Spend as much time trying to find solutions for the issues that they're experiencing as you spend on social media, on your phone, doing the other things that take up a lot of our time. Never tell teachers, well, you signed up for this. Teachers, administrators, they did not sign up to be hit, bitten, kicked, given concussions, have feces smeared on them. They just did not sign up for that. Regardless of what legislation mandates, we have to be responsible for our own children's mental health and trying to find solutions there. We have to be willing to get them the help they need using whatever resources that we have available to us. Federal lawmakers and the U.S. Department of Education, you must reevaluate your mandates that are burdensome and unobtainable in many respects. While they may look good on paper, they are unrealistic, and they are one of the many reasons why teachers are leaving the field in droves. Attrition hurts students and directly leads to their lack of progress. Let's all work together for the benefit of our students. Okay, that's all I have for you today. I hope I have provided some food for thought and given you some useful information Please don't forget to like and subscribe to my channel, and feel free to comment on any further topics that you would like me to share with you. And lastly, let's all go make a difference.